between the appeal Konecny and this court of the public?
Yes, Mr. Towers.
My lords, my ladies, issue of this appeal, namely whether somebody unfairly convicted in their absence and therefore entitled to an automatic retrial, whether that person is sought for the purposes of being prosecuted on that retrial, or whether they are sought for the execution of a sentence, it is easy to state, and in the appellant's respectful submission, easy to answer, but lurking underneath it is some fairly deep water so far as the law of extradition is concerned, and I hope today to guide us through those waters. I'd like to begin, please, with the framework decision, at the end of the story in one sense. It's at Authorities Volume 4, tab 69, manuscript 1229.
It's actually not manuscript. Funnily enough, everyone has assumed that it's manuscript, but it's memory stick.
Memory stick. Manuscript sounds...
Just a moment. Lady Black is... she has done something terrible to her computer and is locked out. So just give us a moment to allow her to be,
I'm fine.
so to speak,
The
locked
light's
in.
away. It will be fine. Thank you very much.
Memory stick then, please. Page 1241 is the European arrest warrant in all its glory. It is, as this court will well know, a compendious single form applicable to all cases. But the information to be inserted in the various boxes depends, like extradition treaties and laws everywhere and since the beginning of time, on whether the requested person is either accused or convicted, or to use the words of the framework decision, whether the warrant has been issued for the purpose of conducting a criminal prosecution, or, on the other hand, for the purpose of executing a custodial sentence or other detention order. Hence, page 1241, the pro forma words that appear on the face of every single European arrest warrant, where the alternatives are intended to be but never in reality are, deleted. That derives from Article 1, Sub-Article 1 on page 1230, which defines a European arrest warrant as one that is issued either for the purposes of conducting a criminal prosecution or for executing a criminal sentence, a custodial sentence. And there the dividing line is drawn, and the substantive and procedural requirements of a European arrest warrant will differ according to which category you fall into. So look, for example, please, at Article 8.1f. A warrant is required, amongst the various things that it is required to particularize, it's required to particularize the penalty imposed if there is a final judgment, or alternatively, the scale of penalties if there isn't. Perhaps more fundamentally still, the grounds of surrender, or more accurately, the grounds of non-execution of a warrant will differ in their application depending on whether your warrant is one for prosecution or for execution of sentence. So Article 4, Sub-Article 6 on page 1232 is a ground of non-surrender or non-execution which applies only to those who have a warrant issued for the purposes of execution of their sentence. It is that provision that enables convicted people to apply to have their sentence served in the state that they are resident in. What used to be Article 5, Sub-Article 1, I say used to be because it's been repealed, but it's probably worth looking at here, is the provision, or the old provision of the framework decision, that enables an executing state to make surrender subject to a guarantee of a retrial in a trial in absence case such as this. It is a provision that in its first form, as we see here, Article 5, Subarticle 1, applies only to those who have or are subject to an EAW issued for the purposes of executing their sentence. Compare Article 5, Subarticle 3, which applies only to those whose EAW is issued for the purposes of prosecution. There are other provisions within the framework decision that depend fundamentally on your classification or your categorization. So, temporary surrender under Article 18 is a process that is available only to those whose EAW has been issued for the purpose of conducting prosecution, not for convicted persons. Article 16, Subarticle 1, in cases where there are competing European arrest warrants issued by different states for the same person, how a court is to determine priority as between them turns, at least in part, that you see from Article 16.1, on whether the respective warrants have been issued for prosecution on the one hand or executing a sentence on the other hand. It can even affect the way that you are transited through other states once your extradition has been ordered. Article 25, Sub-Article 1 has different schemes depending on whether you are being prosecuted or you are returning to serve your sentence. Can I complete this short exercise by taking you, please, to Authorities Volume tab 71, recalling that we looked at Article 5, Subarticle 1, retrial guarantees, just to bring you up to date. That article has been repealed and replaced by a new article, Article 4A, by virtue of the 2009 amending framework decision. And Article 4A begins...
That's at 1336.
It is 1338 is Article 4A. It still applies only to those wanted for the purpose of executing a sentence, but now expanded, strengthened in significant measure so far as defendants are concerned, moved from Article 5, which is optional guarantees that can be attached to an extradition order, into Article 4, which is optional grounds for non-surrender. And as I say, expanded, so now an EAW needs to state one of four things in trial in absence cases. He needs to state A, whether the defendant was summoned, B, that he was aware of the trial and appointed a lawyer, C, that he has been informed about the right to a retrial and decided not to exercise it, or D, will be granted a retrial upon return. These are things that a European arrest warrant now needs to specify on its face. For our purposes, at this stage, I invite your attention simply to the fact that this is one more of those provisions whose application depends on your categorization. It applies only to those who are wanted to serve a sentence. And as you would expect, Part 1 of the Extradition Act works the same way. Tab 70, page 1247, Section 2 at 1248, delineates two different categories of defendant. Under Section 2.3, you can be accused. Section 2.3a refers to somebody being accused in the Category 1 territory of the commission of the offence. That is synonymous, we see from 2.3b, with being somebody subject to an EAW issued for the purpose of being prosecuted. So the Act takes the framework decision's terminology for the purpose of being prosecuted and converts it into common law language, accused, but they mean one and the same thing. And so too at section 2, subsection 5 on the same page. Subsection 5b, a warrant issued for the purpose of being sentenced or of serving the sentence is the same thing, subsection 5a, as somebody who is convicted. And through these provisions...
Just before you go on, does it say that this, in the Act, that it implements the framework decision? Because often these acts, which are European provisions, do make express reference to that. And,
it doesn't on the face of the Act. It is an Act that implements the framework decision. Yes. The explanatory notes, I think, make that clear. Right. But it
can you refer us to those, the explanatory notes?
The explanatory notes, I don't believe we have amongst our materials. I know it doesn't look like it, but we made an effort to cut it down. But I'm sure we can find the provisions that make it clear. For example, section... The framework list is dealt with at... it's referred to in section 64 and 65 when one deals with dual criminality. It is then made part of the Act by section 215 and is Schedule 2 to the Act. We don't have them here, but it includes the framework, the list of 32 categories of offending that are set out in the framework decision.
In any event, your point is that this does implement the framework decision.
Unquestionably, it does, and it has been recognised as such for the last 20 years. That is the function of Part 1. It applies only to European Union member states, or at least it does as it presently operates. And it reflects, we say clearly, the scheme and the structure of the framework decision. It delineates, as we've seen, between people whose EAW is issued for prosecution and those whose EAW is issued for sentence. As with the framework decision, some provisions apply only to one category of persons, some apply only to the other. So the bars to extradition, for example, that reside in paragraphs 11 through to 19, their application depends on whether you're accused or you're convicted.
Yes, and just for my benefit again, please, the Part 1, you say applies only to Union member states.
Those are the only member states who have been designated.
And all Union member states are designated.
All are automatically
Category 1
Category 1
are the
right.
Category 1 states are the EU member states.
Everybody else, yes, everybody else is Part 2. In theory, it would be possible to designate another country under Part 1. It's just never happened because the Act is designed to implement the framework decision, and if the underlying treaty provision doesn't reflect the framework decision, one can see the difficulty. So, having delineated between these two categories of persons, accused, convicted, the Act then sets in train essentially a flowchart, and your route down or through the flowchart depends on whether you are accused or convicted. So if you are accused, for example, by virtue of section 11, subsection 1a on page 1259, you are allowed to argue section 12a, absence of prosecution decision. You are allowed to argue section 19b, forum. You're not allowed to argue either of those two things if you are classified as convicted. And even those provisions that apply equally to both can differ radically in their application depending on whether you are accused or convicted. Now, this case is primarily concerned with Section 14, that's at page 1262. The measure of time that you are allowed to have taken into account under Section 14 depends on whether you are accused or you're convicted. Other provisions of the Act differ radically depending on whether you're accused or convicted. So your dual criminality assessment under Section 10, if you are accused, you're governed by Section 64. Punishability there is subject to a 12-month threshold. If you're convicted, it's Section 65, and if you've been given a 4-month sentence, you can be extradited. After the bars have been decided, Section 11, subsections 4 and 5, on page 1259, determine which side of the flowchart you flow down. If you're accused, subsection 5, you are sent to Section 21A. There you're allowed to argue human rights as a defence to extradition. Of course, that in accusation cases is a forward-looking assessment of what might happen in your prospective trial. It's concerned with quantification of future risk. Under Section 21A, as an accused person, you are also allowed to argue proportionality. You're not if you're convicted. If you're
Well, I think that the significance of whether you're convicted, treated as a convicted person or an accused person is probably fairly clear.
how to decide whether you are
Yes.
accused or convicted.
That's the real issue, isn't it?
Perhaps a different issue. Page 1329, section 68A seeks to define those who are unlawfully at large. You are unlawfully at large if you are convicted and your EAW is issued for the purpose of you being sentenced or serving your sentence. Again, entirely at one with how the framework decision was designed to operate. Can I just invite your attention simply to note it at this stage? I'll come back to it. But subsection 2 disapplies that definition for the purposes of two provisions of the Act. The one we are concerned with, section 14, and another one, section 63. As I say, I will come back to that to explain its significance or otherwise.
It seems there's a transposition note setting out how the framework decision gets transposed into this law.
Yes.
I suppose we haven't got...
I'm sure we can provide it. I hadn't understood it to be contentious that this is the Act that transposes this aspect
just interest.
of EU law. But yes, my lady, of course. So essentially, the part 1 is designed to, and as we have seen does, transpose and reflect the scheme of the framework decision. Now, the issue, of course, in this case is into which category or classification persons convicted in absence but entitled to an unfettered automatic retrial fall. The appellant's case is that such persons are in reality and in law accused, and it's artificial, unrealistic and wrong to say that they are anything other than wanted for the purposes of being prosecuted. They will be prosecuted at their retrial. Now, there is an easy way and a hard way for this court to determine the merits of that submission. Both ways lead to the same terminus, that is to say, such persons are accused. Can I start with the easy way? Because Part 1 transposes EU law, the first route is to ascertain the EU law answer. How are such persons treated under the framework decision? If that emerges with clarity, then of course the court need look no further, because acts such as this are subject to the Pepino EU law principle of conforming interpretation, confirmed by this court in Golachowski. The court is obliged to interpret the Act in conformity with the framework decision. Now, I say this is the easy way. I say that because on this issue, the CJEU has spoken loudly and clearly. Recall, please, that when we looked at the framework decision, Article 4, Sub-Article 6, it was one of those optional grounds of non-execution that it was applicable only to persons wanted for the execution of sentence. Recall also Article 5.3, its mirror provision applicable only to accused purposes, people wanted for prosecution. With that in mind, can I invite you please to open up Authorities Volume 1, Tab 2, Memory Stick, page 38, the judgment of the ECJ, the CJEU, in IB. The judgment begins in the report at Memory Stick 52. Some background. IB was convicted and sentenced in Romania to a non-custodial sentence, paragraphs 25 and 26. That was then replaced by a Romanian court with custody in proceedings in IB's absence, paragraph 27. Romania, pursuant to that, issued an EAW for the purposes of executing that sentence, paragraph 31, and that's important.
I'm sorry, which is the memory stick page, please?
These paragraphs are on, they begin, my lord, on page 57.
57.
The report contains the Advocate General's opinion. The judgment begins at page 52.
Yes, I see that now. Thank you.
Thank you. So, convicted, sent to prison, paragraph 27, in absence, EAW issued for the purposes of executing the sentence, paragraph 31. Then, under the Belgian law, because Mr. IB is arrested in Belgium, and it's Belgium that are called upon to execute that European arrest warrant, under the Belgian law that implements the framework decision, he secures a retrial guarantee, paragraph 36. That is to say, under the Belgian law that implements what was Article 5, Sub-Article 1, now Article 4A, but the old version was applicable to him by reason of operation of Belgian law, paragraph 15. It matters not for our purposes. That's how he got his retrial guarantee. Paragraph 36. The Belgian law in question is at paragraph 21, but it reflects what was Article 5, Sub-Article 1. He was a Belgian resident. He wished for any sentence that he might be called upon to serve to be subject to the condition that it be served in Belgium, where his family were. That presented a problem for the Belgian courts, because firstly, Article 4, Sub-Article 6 of the framework decision, which as we have seen is the provision that would have been in play if he were a person convicted, a person whose EAW was issued for the purposes of execution of sentence, couldn't apply because he hadn't been finally sentenced, paragraphs 36 to 37 of the judgment. Hadn't been finally sentenced because he was entitled to a retrial. But neither could Article 5, Sub-Article 3 of the framework decision apply. That's the mirror provision that would apply to persons accused, persons wanted for prosecution, because under Belgian law, which is set out at paragraph 21, Belgian law treats all EAWs following trials in absence as being issued for the purpose of executing sentences, not for the purposes of prosecution, even if they have accrued a retrial. Paragraph 39 of the judgment. So on the face of it, he was neither under Belgian law. And so the Belgian courts referred to Luxembourg the issue of the compatibility generally of those Belgian laws, paragraph 40. And the first question that was referred to Luxembourg, paragraph 41, subparagraph 1, is the very issue that arises in this appeal. It is our certified question in the language of the framework decision. It asks, essentially, according to paragraph 48, how do we categorize somebody tried in absence, but with the guarantee of a retrial? The ruling of the court begins at 49. The court observed, 49, that the framework decision envisages two different situations: wanted for prosecution, wanted for the execution of sentence. 50. EAWs are not automatically executed. They're subject to exceptions of the type that we have seen in the framework decision. 51, 52. One of those exceptions is assumption of sentence execution by the executing state. It's an issue that is required to be addressed by the executing court. 53 to 55, there is no reason in principle to exclude from those provisions somebody who has acquired a right to retrial under Article 5, Subarticle 1. So, how are they to be categorized? The ratio of the case, paragraphs 56 to 57. Persons who are tried in absence, whose conviction and sentence are not yet enforceable by virtue of the existence of a right to retrial, are to be categorized as wanted for the purposes of prosecution.
Can you help me with paragraph 56? It says, if the sentence imposed in absentia is not yet enforceable. Does that mean there are some sentences which are?
Well, if
is it the ones without a retrial?
Ones without retrial.
Where do we get that from in the judgment?
'57. Given that the situation of a person who was sentenced in absentia and to whom it is still open to apply for a retrial is comparable with the person who is subject to the purposes of prosecution, there is no objective reason for precluding them from Article 5(3). So it is those cases where there is a right to reopen the conviction that renders it as yet not enforceable.
Is it saying that that is so simply for the purposes of these provisions?
Yes.
Or is it laying down a more general proposition that if there's an automatic right to a retrial, that for all purposes it should thereafter be treated as an accusation case?
Well, the strict answer would have to be the first, that the court was directed to address how Article 5, Subarticle 3 works. But in order to do that, the court had to address the more general question of how to categorize a person who is subject to a right to a retrial, whether they are, on the one hand, paragraph 49, wanted for the purposes of prosecution, or on the other hand, executing a sentence. And it's that answer that then dictates, as we've seen, the operation of Article 5, Subarticle 3. And Article 5(3) is applicable to those who are wanted for the purposes of prosecution. There's no suggestion anywhere.
Paragraph 49 doesn't supply the answer, does it?
Well, it provides the background to what the court was deciding. There are only two categories of people into which did this particular scenario fall? Answer, wanted for prosecution. Now that provided, therefore, the answer to whether it was Article 4.6 or 5.3 that applied to this particular case. But it's a finding of more general application.
That's my next question. You say that it follows from that a person with an automatic right to a retrial must be treated for all purposes.
Oh, absolutely. And
as an accusation.
There's no logical reason why Article 5, Sub-Article 3, which applies only to those wanted for the purposes of prosecution, should be treated any differently to all the other provisions of the framework decision.
But if that were right, how could Article 5.1 apply to the person at all?
Do I understand my Lord's question to be, how did he enter 5.1 if he was wanted for the purposes of prosecution?
Well, I'm just reading paragraph 57. You know, there's no objective reason precluding and executing a judicial authority which has applied Article 5.1 from applying the condition in Article 5.3.
Absolutely.
But
essential...
How could Article 5.1 apply if the person were considered for all purposes to be an accused person?
Well, he's considered for all purposes to be accused once he has a right of retrial. So what we're going to see, in our submission, you learn two things from IB. On a general level, you learn that those who have a right of retrial are categorized as wanted for the purposes of prosecution. They are accused in the language of the 2003 Act. But secondly, and equally importantly, what you learn from IB is that you can change during the course of an extradition process. IB began as somebody wanted for the purposes of execution of a sentence. That was the avowed purpose of his European arrest warrant, paragraph 31. As such a person, he he entered into Article 5.1. He emerged from the Article 5.1 process with a retrial guarantee.
Well, can you emerge in the opposite direction? Let us suppose that someone who's entitled to a retrial says that he doesn't want to be retried. Is he then a person convicted?
If
That he elects not to?
potentially, yes.
Exercise.
Potentially that could be the case. What's more realistic, perhaps, is somebody who is offered a retrial and says and argues, well, it's not a real retrial. It may be in form, but in substance, it doesn't give me all the rights I would have under a retrial guarantee. And so in substance, I am still a person convicted. But what IB tells us is that your status can change during the course of the extradition process.
Well, does it say that? Because if you look at 57, it says the position is comparable to the other situation.
Yes.
It's comparable to it. It doesn't say that it's transformed into it.
But he was, on the ruling of the, well, our submission is that's what the court meant. You are transformed into somebody who is accused, because otherwise you can't have access to Article 5, Sub-Article 3. And the court's essential ruling was that IB was entitled to pray in aid Article 5.3. Yes. And that can only have happened if he had been transformed, not just comparable to, but actually became somebody who was now wanted for the purposes of prosecution. And all of that makes perfect sense in our submission. He began life as somebody wanted for the purposes of executing his sentence, paragraph 31. He entered Article 5.1 as such, because that's the only way you can get into Article 5.1. He came out with a retrial. On any sensible view, he is now somebody wanted for the purposes of facing a prospective prosecution. Rationally, he is now accused or wanted for the purposes of that prosecution. He's become somebody now wanted for the purposes of prosecution, and he has become somebody who now has access to those provisions of the framework decision that exist only for that category of people.
Well, it's only 5.3 of which he speaks. I mean, a narrower ratio would be that where you are a 5-1 person, but you have a right for a right of retrial, then the court is construing 5.3 more broadly than the literal wording of 5.3, so that such a person, because he is in a comparable position, can have the 5.3 right. I mean, that might be the whole ratio of the case.
Potentially, but there are other aspects of the framework decision that then, and subsequent to Article 5.3, also depend on whether you are wanted for the purposes of sentence or for the purposes of prosecution.
Yes.
And it would be odd if he were wanted for the purposes of prosecution there, but then considered as something completely different in, say, Article 25 for the transit provisions. Or
But
Article
as Lord Jones says, the use of the word comparable suggests that the status isn't changing, but it is comparable for the purposes of 5.3.
But it's,
therefore, 5.3 is given a broader interpretation than one might otherwise give it.
well, if that is how juridically we are to address it at European level, then so be it. But it can't just be Article 5, sub-Article 3 that is given the broader interpretation. All of those articles to which, as an accused person, he would be entitled to have access must be given similarly broad interpretations. And whether we regard that conceptually as somebody's status changing or the framework changing to accommodate them, perhaps matters little. The point of IB, for my purposes, is firstly, it tells us how to treat, and I use the word treat advisedly, treat somebody who is tried in absence and now entitled to a full retrial. But it also tells us in our submission that that isn't the end of the equation. There has to be a reconsideration of that person's status, or else a reconsideration of the framework in which they are being considered in order to accommodate that changed position.
Does the Advocate General help us at all?
Not on these issues. So in the language of the Act, in our submission, either, if I'm right, somebody enters Section 20 as a person convicted and emerges as a person accused, their status has changed, or else they emerge as somebody comparable to a person accused, and the Act has to be expanded, adjusted to accommodate their new comparable status.
Section 68A, the definition section.
Yes.
That flags the possibility of a varying meaning for unlawfully large. Is that reflecting something in the framework?
No. I will come to Section 68A. I'm not trying to avoid my lady's question.
It's nothing to do with IB?
No. And you know it can't be, because it's only concerned with Sections 14 and 63 in the process of adjusting the meaning of unlawfully at large. It doesn't adjust the meaning of unlawfully at large for all of the other provisions of the Act that apply only to accused persons.
Right, let's move on then.
So that was the easy way. The harder way, by which the court can and should arrive at precisely the same endpoint, is to do it through the common law. Pretend that...
Sorry, can I just interrupt you?
Yes.
Is it permissible to do that if this is an act implementing the European legislation? To go back to our domestic law and consider the Act in the light of that? I mean, is it not a matter that must be construed in the light of the European...
Well, it's certainly, if I'm right about EU law, that is the answer, and the court need and should go no further. But if I'm wrong about this, and the answer doesn't emerge clearly from the jurisprudence of the CJEU, then we're going to have to find the answer another way. And that would be...
Well, forgive me, before you move on, if you're right on your submission in relation to IB, this is a pretty fundamental change, isn't it, in the whole of the EU law relating to the European arrest warrant, because you now have to reconsider every case in order to determine whether there's going to be a right of retrial or not.
That's certainly been the way we have always dealt with extradition requests. That's, as we will see when we look at how the common law has addressed exactly the same problem over the years, it is part of the extradition court's function to determine whether there is a right to a retrial and then categorise the person accordingly. And that has had to happen as a matter of jurisdiction under the 2003 Act. And Caldarelli, and the House of Lords and Caldarelli,
but confining attention for the moment to the position in EU law,
yes.
Is there any authority other than these two paragraphs in IB to support this proposition?
Well, IB is the authority that deals directly with this issue. There is other authority, but it's... I will come to it when I deal with Caldarelli. Caldarelli essentially has found that the cornerstone for deciding whether somebody is accused or convicted is whether their conviction is final, in the sense of finally enforceable. That has been broadly approved of at ECJ level in a case called Tupikas, which holds essentially that the EAW, when it speaks about convictions and the like, is talking about final convictions. So yes, indirectly, but IB is the case that deals with it in terms.
Well,
Thank you.
Rather apprehend that my Lord's question portends the issue of whether this is acte clair in European Union jurisprudence.
Well, in
your submission is that it is.
Absolutely. Our submission is that IB is unambiguous. How one accommodates the machinery to accommodate it is perhaps a more difficult question. Mm-hmm. But the underlying categorization, as emerges from IB, is that somebody who has accrued a right to a retrial is, and only is, to be regarded as somebody wanted for the purposes of prosecution, because that is what a retrial is.
Even if he disavows his right to...
Well, if somebody disavows a right to a retrial, then the EAW would presumably revert to being one wanted for the purposes of executing the sentence. Personally, I've never seen it happen, but I would suggest that it were impossible to do. And we are always concerned with the right to a retrial. It's always open for somebody to disavow themselves of a retrial for whatever reason they wish to.
Right.
But juridically, yes, that would be open.
Okay.
Can I deal with the common law in this way, simply to show that it arrives at and supports the way that the CJEU has interpreted and answered exactly the same question?
Sorry, I'm sorry to stop you again, but I am troubled by this. I mean, if it is a question of union law,
yes,
then one can't infer that the union law has been framed in the light of our common law, can one?
No, absolutely not.
So is this entirely a question of union law? What's the common law got to do with it on this assumption?
Well,
you say there are two ways we can get there,
yes,
but I'm not sure that they aren't mutually exclusive. Is it one or the other?
Can I give two answers to that
Yes.
question? Firstly, I've been questioned about whether the ECJ has really meant what it said. In our submission, yes, it does. And it's no coincidence that our courts have said precisely the same thing over 150 years. But secondly, remember, please, that this Act also applies to countries outside the Union. And Part 2 makes precisely the same distinction as between convicted and accused. Section 82 works in precisely the same way as Section 14. So if this were, for example, a Trinidad case, and I were here arguing that the Act fell to be construed in the way that I say it falls to be construed.
Well, I understand part two, but that may
ECJ
be
law-
different. I mean,
yes.
just supposing that the answer provided by union law was different from the answer provided by domestic common law.
Then the union law would prevail.
Yeah. So this is really analogical. You're really drawing an analogy between the distinction made in common law with the distinction that you assert should be made in European Union law.
Yes.
But I think we can deal with that fairly briefly, can't
Well,
we?
I hope so. But insofar as the court has doubts about how the EU position has developed and the conclusion that the EU court has arrived at, it ought to be some comfort to know that the UK courts have arrived at precisely the same conclusions over a prolonged period of time.
Yeah. Well, I think
So-
that's probably, you would accept, a fairly limited relevance, so we can deal with it succinctly.
I will take that cue and I will do my best. So the common law has long held that persons with a right to a retrial are to be treated as accused for the purposes of extradition legislation. Dealing with it as quickly as I can, the common law begins in Coppin, Authorities 1, tab 11, unfettered right to a retrial, judgment pages 53 to 55. How, asks the High Court, can such a person be categorised other than as a person accused? And it mattered then because you could only extradite accused people under the treaty then in force. Then Caban Waterfield, tab 12, the obverse, no right to a retrial, final judgment, but committed nonetheless to be extradited as a person accused. Court held that Coppin was clear. The judgment begins at page 290. The relevant part of this judgment begins at page 290. Coppin is clear. It is to ensure that the Act, then the 1870 Act, is in line with Coppin, that it contained what the respondent here calls a deeming provision, what is in fact a provision that is declaratory of the common law established by Coppin, section 26. Court applied Coppin, page 292. Reality, in no sense of the word, is a person with no right to a retrial accused. House of Lords in Athanasidias, tab 13. Coppin is clearly right. Pages 306 to 308 of the judgment. There, the right to a retrial was conditional or contingent. That is insufficient to render somebody accused. They remain convicted. Pages 307 to 308. House of Lords spoke again in Zeza. Same situation, final conviction, no retrial. Such people are convicted, not accused. I think this is probably the only time I need to do this. Direct your attention, please, to pages 330, memory stick 330 and 331. Two comments, according to Lord Roskill, that should be made upon the decision of Coppin, which has stood unchallenged for over a century. Letter B. Firstly, it negatives the contention that an English court must look only at the name of the process and not receive expert evidence as to its true nature. Secondly, accepted that the purpose of section 26, that's the deeming provision is to give statutory effect to the decision in Copin. Next paragraph, the English court will receive evidence of the relevant foreign law, and having done so will then decide, in the light of its findings upon that law, a question of fact, that is to say whether or not the conviction in question is one that can be described as a conviction for in contumacy, that is to say one that can be reopened as of right.
Yeah.
Must inform itself by evidence. Evidence will show whether it's in contumacy, so the matter can be reopened in the event of surrender. If it can, paragraph F, then the person concerned must not be treated as convicted, but as an accused person. Caban-Waterfield is right. And then over the page at B, Caban-Waterfield is clearly correctly decided, plain authority against the view that the English court will not look at the nature or substance of the conviction. And then lastly at D, notwithstanding the name given to, or one might say the label attaching to the Italian procedure, you should look at the true nature and effect of that procedure as it is operated in Italy. That is to say, to find out whether the judgment is final or not. There it was, so he had been rightly categorised as convicted.
How do we know that the English court still does the categorising under the European framework?
Because that's the only way to decide in a retrial case whether somebody is accused
No, it
or is
isn't.
convicted.
There's two boxes on the warrant,
Yes.
and the requesting state fills them in. And you could categorise according to that.
You could just accept what the requesting state says by way of...
That's not an unusual European way of dealing with things.
To jump forward in the chronology, the answer to my lady's question is Caldarelli, Lord Mance, paragraph 42, where he repeats in the context of part 1. Caldarelli is at tab 34 of volume 2, paragraph 42,
What was the page? Sorry.
612 of the memory stick.
261.
Paragraph,
42.
thank you.
Letter G, whether the dichotomy is drawn by reference to European or English law, the view of a court of a foreign requesting status to the correct categorisation cannot on any view determine the matter. Now that's a reference back to the Zeza approach. You can't just take the label given to it by the European court and assume that that is an accurate reflection of either the common law or European law on how to treat somebody who's tried in absence. And what we're going to see is that European judges can frankly get it wrong.
But could we just look at Lord Bingham at paragraph 24?
Yes. Paragraph 24.
It's not quite as absolute a statement as Lord Mance, perhaps.
Well,
He says
What?
that the EAW is a judicial decision which this country must execute on the basis of the principle of mutual recognition. It may in some circumstances be necessary to question statements made by the foreign judge, even where the judge is duly authorised to issue the warrants. But ordinarily, statements made by a foreign judge in the arrest warrant, being a judicial decision, will be taken as accurately describing the procedures under the system of law he or she is appointed to administer.
absolutely. But what Lord Bingham is not... This is the mistake that Isternek made. What Lord Bingham is not saying there is the issuing state gets to decide categorisation. He is talking about how the UK court goes about the exercise of examining for itself whether the conviction is final or not under the law of the issuing state. And in that exercise, he is saying that relevant statements as to how local law treats this conviction, whether it's final or not, statements about that made by the issuing state are usually to be trusted as accurate. The product of that exercise in Caldarelli is to be seen at paragraph 3. under Italian law, 3F, the first instant judgment
Can
and
you just give us
Sorry, where are we
the
then?
citation?
So
The reference.
602, I think.
602, my lord. So the court isn't saying, look at the EAW. If it says accusation, that's the end of the story. What Lord Bingham was saying, you have to look at the underlying reality of the situation. And in that exercise, of course, you take what you're told by the issuing state about whether this judgment is final or not under local law at face value. But you still have to examine the local law, which is what the court did. The product of that factual evidential examination is paragraph 3. The result of it at F was that the evidence showed that the first instance judgment and sentence are not under Italian law either final or enforceable until the criminal appeal process was concluded, not regarded as convicted until it became final. If extradited, his custody would be pre-trial custody until all appeals have been exhausted, not entitled to a retrial. So that's the kind of evidential assessment that the court is required to engage in, whether under the old law or the European law. It's that evidence which then enabled counsel for Italy to make the submission it did at paragraph 19.
So the effect of that evidence was agreed.
Yes, ultimately.
Yeah.
That led counsel for Italy to make the submissions that he did at paragraph 19. In Italy, a criminal trial is not, as here, an event, but a continuing process, because that's what the evidence showed. That was the product of the evidential examination I'm talking about. And then back to 24, to cement, please, that what Lord Bingham is there talking about. Where my Lord finished, Lord Bingham went on. Here, common ground that the foreign judge has treated the appellant as accused and not a convicted person seems strange to an English lawyer. Now, if of course, judge issuing accusation warrant was end of story, that would have been sufficient for Lord Bingham's purposes. But he goes on, such is not the practice in Italy. This is at G, my lord, where the trial is indeed a continuing process, not yet finally completed in this case, and not an event. On the evidence, those are the key 3 words. On the evidence, the appellant falls within section 11.5. That's to say he's an accused person, because that is what the evidential examination of the reality of the position in Italy showed in that case. Mm-hmm. And the same appears elsewhere. Lord Carswell says the same thing, I think, at paragraph 36. But the essential point is the court didn't end its inquiry with the label that had appeared on the European arrest warrant. It went on to consider the reality of, and that accords entirely with the Zeza approach.
But it did that on the basis of evidence.
Absolutely.
Foreign law.
Yes.
Yeah.
Yes. And of course, if the issuing judge decides to contribute to that evidential process and say, well, look, under Italian law, it's a continuing process and this judgment isn't final, what Lord Bingham is saying is, generally, you should be trusting that he knows what he's talking about. But it would be wrong to misread paragraph 24 as authority for the idea that an accusation EAW is and always must be an accusation EAW. The foreign judge has correctly categorized this person as a matter of EU law. That doesn't follow at all. Categorization follows from an examination of the finality of the judgment itself. And you see that from the end of paragraph 24. Lord Bingham goes on, in terms of recital 1 of the framework decision, he has not been finally sentenced. Article 8F, no final judgment. Finality is the key. And it's incumbent on the court to determine finality, whether the judgment is, in fact, final. And that is how the courts have dealt with this issue over the years, consistently.
So in that case, it was an accusation warrant.
Yes.
and the court, there was an attempt to persuade the court that it should have been a conviction.
Absolutely.
And the court then looked at evidence
And determined that it was, in fact,
an accusation.
rightly categorised as an accusation warrant.
Because the appeal itself wasn't yet over, and
No,
therefore there was quite apart from the retrial, there was a continuing trial in Italy.
There was no retrial. There was the first instance trial simply hadn't come to an end yet.
Yeah.
And it was only it wasn't just by looking at the label. Lord Mance makes clear that you can't do that.
No.
It's by looking at the reality of the situation, and that's the Zeza approach that we have just seen. Labels aren't necessarily that helpful. The court has to look at the reality of the situation to determine whether somebody is accused or convicted.
So it's a combination then on this analysis of union law and the domestic law of the country where the person has been or is being prosecuted.
Yes, the only reason union law comes into it is because by the time Caldarelli is decided, the framework decision has come into effect, and Caldarelli is making the point that the way we have always dealt with this is entirely consistent with the way the framework decision is intended to work. It's consistent with the union law position. There's no need for any change. You keep on making these evidential inquiries. And your answer to that evidential inquiry determines, as a matter of law, whether that's union law or common law, they're the same thing, says Caldarelli, whether somebody is accused or convicted.
Yes, but my lord, I think makes a different point. I mean, what union law prescribes is that its distinction is to be made, but there has to be an examination of the outworking of the proceedings in the particular national order in order to decide into which category it falls.
Yes. Yes, absolutely. But so did common law. What Caldarelli is telling us is that there's no difference between the approaches required by the common law and always undertaken and the new approach overlaid on top of that by union law. One can keep them separate, but one could also regard them as synonymous. They amount to and arrive at exactly the same thing.
Right.
There are a great number of cases under the old, before the framework decision came into effect, that laid down the system that Caldarelli then carries into the framework decision. Can I just refer you to three of them and then stop? And I want to do it for this reason. Can I headline why I want to do it? Because these authorities tell us in terms that, firstly, those with trials and absence are properly categorised as accused. Secondly, the fact that a trial in absence may only materialise following an application after surrender doesn't matter. And thirdly, it was always envisaged that somebody's status could change during the course of an extradition case. So, tab 23, please, 4. Foy was a French case, convicted at absence, sought as accused because he had a retrial guarantee. The court held at pages 416 through to 418 that he was indeed accused, according to Coppin, Caban Waterfield, Zeza, all of those cases. At page...
This is under the 89 Act.
This is under the 89 Act. The importance of drawing these, there's three short cases that I think we need to look at under the 89 Act, is to deal with the point raised by the respondent on deeming provisions. That all of this is the product of some faux or deeming provision inserted into the old legislation which forced the court to deal with these cases other than that which they really were. The point about these cases, European cases under the 89 Act, is that they were subject to no deeming provision. Section 35, subsection 2, applied only to Commonwealth countries and colonies. There was no deeming provision that forced the English courts to treat in European cases, Part 3, European cases under the 89 Act, persons with retrials as accused, but they continued to do so. They did so because Coppin, Caban, Waterfield, Zeza were all manifestly correct. Because of the absence of a deeming provision, counsel for Mr. Foy felt able to submit, as you see from the bottom of 416, that the whole idea of contumacy had been swept away. The court disagreed and applied Coppin, Caban, Waterfield and Zeza. In the course of doing so, it made reference to section 6, subsection 2. That's the predecessor to section 20 of our Act, Article 4A of the Framework Decision, and makes this point: they were never intended to give relief to somebody who is entitled to have his conviction set aside. Such persons, page 417, do not need further protection. They are treated as accused. And then there is reference to the recommendations of the Interdepartmental Working Party that preceded the 89 Act, recommendation 15 of which was as follows: if the requested state gave an assurance that the fugitive would be returned to be tried again for the offence, etc., the fugitive should be retreated as if he were an accused person. And then following on from that quotation, this was the genesis of section 6, subsection 2, never intended to apply to those in the position of this applicant.
Could we just have a quick look at section 6.2? I think it's...
Yes. The 89 Act is page 1190, tab 68 of volume 4, section 2. 6 subsection 2 is at page 1198. Like the new section 20, it applies to only those alleged to be unlawfully at large after conviction, and is, in essence, the provision by which somebody said to be finally convicted gets to argue that that's not fair, and they should be entitled to a retrial, perhaps because they weren't summoned, weren't properly represented, weren't able to cross-examine witnesses, etc. And if their submissions have merit, more often than not, they are met with a retrial guarantee. So you have in your materials, my lord, a series of cases from Italy, Cavallo, Baroni, Faro, Seduto, where justice required somebody to be given a retrial, but Italy couldn't, and so they were discharged under section 6, subsection 2. And other cases, such as Pecci, where Switzerland justice required a retrial. There's no evidence that Mr. Pecci knew about his proceedings, and Switzerland was able to guarantee it. So the essential points to take from Foy are as follows. Firstly, Coppin is good law. Contumacy was never swept away. It's not dependent on deeming provisions. At page 418, just for my lord's, my lady's note, the fact that a right to a retrial is dependent on an application being made in due course Doesn't matter one bit, said the High Court, page 418. FOI is also authority for the proposition that mechanisms such as Section 6.2, now Section 20, also Article 4A, all of which apply only to convicted people, were never intended to apply to people possessed of a retrial because they're accused, not convicted. And thirdly, you see in FOI reference to the recommendations of the Working Party that if a right to a retrial arises during the extradition process, so somebody enters Section 6, subsection 2 as a person convicted, emerges from it with a retrial like Mr. Pecci did, then their status changes and they are to be retreated as a person accused.
Where do we say that in FOI?
We saw that back, please, to FOI, page 417, where the court is quoting the recommendations of the Working Party, which are then incorporated into Annex B of the Green Paper. If the requesting state gives an assurance of a retrial, the fugitive, quote, should be retreated as if he were an accused person.
Mm-hmm. Yes, thank you.
So that's his status is changing. He's entered Section 6, subsection 2 as a person convicted, emerges as a person accused because he's got a retrial, he's got to be retreated as a person accused. And that's in our submission only right. He is now in reality somebody going back to face a trial. He ought to be treated for the purposes of extradition as such a person and entitled to rely on all of those provisions of the Act, whatever Act we're talking about, that offer protections to such persons. I said I'd refer you to three authorities. FOI was confirmed as being right in BICAR, tab 28, volume 2, memory stick 474, paragraphs 19 to 35, and again in Hewitson, tab 31.
Sorry, you're going to have to...
Sorry, my lord.
Which paragraphs in BICAR?
So BICAR
Which
is at tab 28. It begins at memory stick 470. No, 474. And at paragraphs 19 to 35, my lord, the court deals with and rejects an attempt to argue that FOI was wrongly decided.
Before you move too far away from FOI, you said that Section 6.2 was the precursor of Section 20.
Yes.
But it's actually, Section 20 is very different.
Oh, absolutely. It's been developed and...
and we haven't heard a lot about it at the moment.
Section 20.
We've sort of started with Europe and not with our Act, but it's very different.
Section 20 is definitely a development of the protections that were in existence under the 89 Act under Section 6.2. There has been over the years an increasing and maturing recognition of the problems that are presented by trials in absence, and Section 20 represents that. So in 2003, Section 20, which my lady will find at memory stick 1273, so tab 70, page 1273.
And this is the first piece of legislation after
Framework
the
decision.
framework decision.
Absolutely.
And there was no earlier framework decision.
So the framework decision comes into play. It had at that time Article 5, sub-Article 1, which was a fairly benign provision, enabled member states to make extradition conditional on retrial guarantees when the justice required it.
Yes.
Our Act went a lot further, but recognising perhaps the common law's aversion to trials in absence. Section 20 is plainly an attempt to build into our new legislation something that resembled the Article 6 European Convention on Human Rights jurisprudence on trials in absence. So this was a unilateral attempt by the UK to strengthen the protections for those who were tried in absence, to deal with the situations of deliberate abstention and entitlement to a retrial, and the content of an entitlement to a retrial. But Section 20, like the old, weaker provision in the 89 Act, only applies to persons convicted, unlawfully at large after conviction. That flows from Section 20, subsection 1, and the reference back to Section 11. You can only get to Section 20 if you are 11.4, unlawfully at large after conviction. So the scheme is the same, but the level of protection is different. Ultimately, Europe was going to catch up in 2009 when it replaced Article 5.1 with the new Article 4a, tab 71 of our volume. But because we had got there first, there was never any need for the UK to amend its legislation to incorporate the new Article 4a. It already had it. So my lady's absolutely right. The protections, the substantive protections within Section 20, Article 4a, have developed over time, but the mechanism remains the same.
I think that the follow-up question was really going to be this, but perhaps you're coming to it later, that reading it on its face, Section 20 incorporates people who've got the right to a retrial, because it's one of the questions the judge has to ask.
Well, again,
I think your answer's to do with flip-flopping between the categories.
If you already have a right to a retrial, you are already accused and you never enter Section 20. In the flowchart of the Act, you're accused from the beginning and you avoid Section 20 in the flowchart.
But how can Section 20, subsection 5 then arise?
Well, it arises in circumstances where you are tried in absence, there is no right of retrial, and the purpose of the European arrest warrant is to execute the sentence. You, as a person convicted, unlawfully at large after conviction, wanted for the purposes of execution of sentence, you then enter Section 20, as you would Article 4a at European level, and it's there that you get to say, well, hang on, I wasn't told about this trial. I didn't have a lawyer present. It wasn't fair. Procedurally, my lawyer wasn't allowed to cross-examine. And the court then gets to assess there whether it's right that there should be a request for your extradition for the purposes of executing a sentence, or whether you should in fact be somebody who should be retried. And more often than not, people emerge from Section 20 with a retrial guarantee, if the justice requires it in any event.
Sorry, so can I be absolutely clear? Going back to Section 11, your submission is that if a person has an automatic right of a retrial, they fall within Section 11, subsection 5.
Yes, they're
Is that right?
accused. Coppin, Foy...
They never get into the Section 20 process at all.
Absolutely. And they don't need it because they have their unconditional
Yeah.
automatic right to a retrial.
Yeah.
Section 20 is an irrelevance to them. And that's what Foy tells us in terms. Provisions like Section 20 and Section 6, subsection 2 before it, were never intended to apply to these people. And by these people, I include this appellant. They are intended to bite on a completely different situation. They're intended to bite on the situation where somebody is convicted in absence, but the requesting state is saying, we want to enforce that sentence. We don't want to give you a retrial. The purpose of this warrant, like in IB, is to enforce the sentence. And it's Section 20, before it, Section 6, subsection 2. It's these provisions, these mechanisms that enable the court to say, well, hold on, justice requires a retrial in this case, so if you want him back, you're going to have to give a retrial guarantee. And that's their purpose. So says Foy, Bickar, Hewitson, amongst...
The distinction is between a situation where he's automatically entitled to a retrial, or whether an examination has to take place as to whether he should have a retrial.
Yes, my Lord's absolutely right.
And if he's automatically entitled to a retrial, you don't have to have recourse to Section 20 at all.
Because he's accused from beginning to end. He goes through the flow chart as
See,
a person accused.
Back to section 11, you're straight into subsection 5.
Yes. So you've gone through the bars to extradition as an accused person. You've been able to argue for him under 19B and 12A. You emerge as you entered as a person accused, and you're sent straight to 21A, which is the human rights, proportionality, temporary surrender provisions that all apply to persons accused. You are from beginning to end a person accused. There's no need for you to go anywhere near Section 20 because you've got your automatic retrial.
I wonder about that, because subsection 5 of section 11 says if the bars to extradition are decided in the negative, the person is accused but is not alleged to be unlawfully at large after conviction of it. And that latter phrase takes us to section 68A, does it not?
Yes.
And 68A then looks to, it says that a person is alleged to be unlawfully at large after conviction of offence. If he is alleged to have been convicted of it, that's presumably a reference to what the warrant says,
Yes.
and his extradition is sought for the purpose of him being sentenced.
Absolutely.
And again, we're looking to the warrant.
But you're looking to the substance of the warrant. You're not looking to the labels in the warrant. You're looking to what is actually the reality of the situation. And somebody this is all of a
But
piece.
this is about allegation. It's not saying he has been convicted. It's saying these allegations are made.
He's alleged to be convicted, and that this is important. His extradition is sought for the purposes of serving that sentence. And somebody who is to be retried is not IB, FOI, all of those authorities, not somebody who is requested to serve the sentence.
Can I follow through, going back just a little way, your point about section 20, subsection 5, please? You're postulating that if you've already got a right of retrial, you go straight to 21A, where you can argue human rights and proportionality.
Yes.
Yes? But if you only get your retrial by going through section 20, and it emerges in the course of section 20, that takes you to section 21, where you've
Yes.
got no right to argue about proportionality.
That's
What's the justification for that?
well.
Or does it suggest that this isn't the way it works?
Well, the justification is perhaps unintentional. This section 20, subsection 6 is ultimately not a problem that arises in this case, because this is a case where the appellant was accused from beginning to end. But where a person is said to be properly and finally convicted, but successfully argues that they should be entitled to a retrial, they do so under section 20. They, according to FOI, according to the Green Paper, according to IB, ought to emerge as a person accused.
But they don't, because they go, well, they're not in as good a position as the person who's been accused all the way along.
Well, section 20, subsection 6 is, and my lady's absolutely right to identify it, is a drafting problem for compliance with what European law requires. Now, firstly, the court ought to understand that sending somebody who's emerged from that process with a retrial to section 21 is almost certainly an oversight on the part of the legislature. I say that because section 21 in its original format covered both categories of people. It was the human rights provision to which everybody ended up at the end. The various limbs of the flowchart converged on section 21. It is where the human rights provision of the Act resided for persons accused and persons convicted. In 2014, Parliament introduced for persons accused a proportionality bar to extradition to ensure that it only applied to persons accused. It was necessary, it seems, for Section 21 to be split. Section 21 remained the end point for people convicted. Section 21A became the end point for people accused.
So the 21A in subsection 1 has two elements. There is a convention rights element, which, for example, if there was an Article 8 claim, would have its own proportionality assessment.
Yes.
And there is a separate proportionality assessment over and above that.
Yes.
Completely remote from human rights.
Yes, absolutely. And that's the product of trivial EAWs being issued throughout the Union. This was a parliamentary reaction to that.
This is a reaction to the complaints against certain member states who handed them out like confetti.
But the point of this is, in order to bring that protection into force for accused people, Parliament decided to split Section 21 into two, and accused people were now sent instead to 21A. But there wasn't any tidy up. So insofar as people who emerge from 20 subsection 5 as accused are still sent to 21, it's likely as not that that was an oversight on the part of Parliament. But I accept that that still doesn't solve this problem. If you emerge as a person accused, as we say, IB dictates that you must, FOI says that you do, as a person accused, you ought to have access to all of the antecedent questions that you ought to have been allowed to access as an accused person. So Section 12A, Section 19B forum, the validity issues that would have applied. You ought to be put back into the position that you should have been as an accused person from the beginning. And Section 20 doesn't do that. This is where the European law comes into play. The common law would require you, under the Assange principles of parliamentary intent, to go so far and only so far as Parliament intended, so far as recategorising people as accused. And there I accept you would have run up against the problem of Section 20, subsection 6. The European law intervening on this, that is to say, IB requiring this court to retreat somebody who emerges from the Section 20 process as an accused person, to retreat them as accused, is an entirely different animal altogether. The fact that it's required by union law requires this court to find a solution consistent with union law. And that's an obligation that is much stronger than the old common law presumptions of Parliament intending to comply with its international obligations. That obligation, assuming you can't read Section 20 in the way that it needs to be read in order to retreat somebody as accused, the obligation on the court is to look at the rest of the national law and find a route to do so. That obligation emerges from Pupino, paragraph 47, recalling that the primary obligation is to apply national law in accordance with EU law. And to interpret it in the way that achieves the purpose and result required by EU law, let's assume that Section 20 is not capable of being applied and interpreted in that way. The obligation on the court then, under paragraph 47, so this is memory stick, page 35, when national law cannot receive an application which would lead to a result compatible with the framework decision, then the court is required, where necessary, to consider the whole of the national law to assess how far it can be applied in such a way as to not produce a result contrary to the framework decision. So even if Parliament has erected a straitjacket that forces the court to deal with people who emerge from Section 20 with a retrial, forces them down the conviction tube, the obligation of this court is to find a way to reverse that, to consider the whole of the national law and arrive at a solution that does retreat that person as a person accused and give him access to the various bars to extradition that accrue to a person accused. Now, we submit there are two routes by which that can and must be achieved. We submit that validity, Section 2 validity, is a continuing jurisdictional issue that subsists throughout the whole process.
Sorry, could you just let me have that again?
Validity, Section 2,
Yes.
is a continuing jurisdictional issue that subsists throughout the whole process. At all times, the court must have a valid European arrest warrant in order to be proceeding anywhere. And if a European arrest warrant becomes invalid, becomes no longer correct, no longer accurate, then a court is required to act on that.
So what invalidates the EAW in your analysis?
Somebody with a European arrest warrant with all of the conviction bits completed has entered Section 20. They emerge from that process with a retrial guarantee. They are now accused under European law. Their European arrest warrant now needs to be looked at again to see if it is valid as an accusation European arrest warrant under Sections 2.3, 2.4. Does it contain...
Well, in plain terms, if the warrant identifies the person sought to be returned as a fugitive, and it transpires that, in fact, he's an accused person, then you say that the warrant is invalid.
Well, at that point, once he becomes accused, the warrant is no longer valid for the purposes of his lawful extradition. It can be made valid. That's why we say this is an available remedy to the court. But the court has to stop. The court has to stop at Section 20, subsection 5, and make sure it is still dealing with a valid European arrest.
Well, how can it be made valid?
It can be made valid. One looks back to Section 2, subsection 3, that he is now somebody who is accused. He is now somebody who is being prosecuted again for the offence. Does the European arrest warrant contain the information required for such a person? That is to say, all of the information in subsection 4. It might. In this particular case, it would.
So it doesn't require any amendment of the warrant?
It might require amendment. If, for example, the warrant doesn't say the scale of sentencing that would be available on that retrial.
But if the warrant outlines the background circumstances sufficiently so that the status of the person as a fugitive as opposed to an accused person, can be dealt with within the terms of the warrant, it doesn't require amendment. Is that right?
No, my lord's absolutely right. It'll be a fact-specific decision. You look at the warrant again. Is it now valid as an accusation European arrest warrant? Sometimes it will be. It'll contain all the right information. If it doesn't, what Golichowski tells us is that it can be cured. You then ask for the missing information, and you're now back at the stage of having a valid European arrest warrant.
So in this particular case, if the judge had treated the warrant as outlining the circumstances in which the appellant was an accused person, as opposed to someone who's convicted and therefore a fugitive, then he could have proceeded accordingly without any amendment of the warrant.
He could have done, but our submission is, once you're back to Section 2, it would then be open to the judge to then proceed back down the right bit of the flowchart.
Well, that's what I mean.
So the solution to the problem identified by my Lady Black is to stop, to reassess validity in view of the new information. If you have a valid warrant, you then proceed as you would and should have done had this been an accusation case. Can I give my lord an example? Somebody is convicted of driving whilst disqualified. They are sentenced to 4 months. As a conviction case, that satisfies all of the requirements of the Act. You're entitled to be extradited because your dual criminality threshold is the right level for a conviction case. If that accrued from a trial in absence unfairly, such that there had to be a retrial for that, you would then sit back and say, well, is this now a valid accusation case? An accusation case would require the EAW to specify the range of sentences available to this offence, assume the maximum was 4 months. That would then not be a warrant capable of being executed because it wouldn't meet the dual criminality threshold for an accusation case. There it's 12 months. There has to be an offence which is capable of being sentenced with up to 12 months imprisonment. So that case would stop.
Yeah.
And that's the kind of injustice that has to be dealt with in the situation that we're... It doesn't arise in this particular
No, I was
case.
going to say, it's not pertinent to this case.
It doesn't take a stretch of imagination to see that there will be cases where, once you move from being convicted to accused because you have a retrial, everything gets to be decided again. The antecedent questions that fell to be decided as a convicted person would now be decided differently as an accused person, and the result could be completely different. But the juridical basis for how the court proceeds is stop, reassess validity. If you don't have and can't have a valid accusation warrant, then you just stop. But if you can, if it can be made good, pursuant to Bob Dodgy, Golichowski, all of those cases which say that validity is fluid, well, then you start again. You start again, and you go through the process again, asking all of the questions that you should have asked the first time as an accused person. Now, we say
I think we have that point.
Yes. We say that is one route by which this court can and must ensure compliance with EU law.
Yeah.
If IB requires you to retreat somebody as accused once they emerge from Section 20 with a retrial guarantee, then that is one route to do it. Another route could potentially be a Zakrewski stay, or a Zakrewski abuse of process. So Zakrewski, my lord, is Volume 3, tab 48, memory stick 824, paragraph 13, sets out a framework in which at a time when validity was fixed and problematic, this court found a different way around problems and erected an abuse jurisdiction to deal with changing situations. So if your status has changed, you've become accused, then another way of giving effect to IB would be to stop and ask yourself whether proceeding as a conviction case is now abusive. But firstly, you would say that the statements in the warrant are now wrong and incomplete, the first limb of Lord Sumption's test. You would say that the true facts required to correct that omission and error are clear and beyond legitimate dispute. Of course they are, because they emerge from the retrial guarantee given by the issuing state. And thirdly, you would say that the omission is material to the statutory scheme. Of course it is, because it determines whether this person should be granted access to all of those antecedent questions applicable to accused people. You would determine in those circumstances that proceeding onwards down the conviction tube, section 20, subsection 6, would be abusive. And you would ask yourself, what remedy do we give? The remedy for abuse is an entirely flexible one. Sometimes it will be a stay. It doesn't have to be a stay. An entirely suitable remedy would be begin again. Come off the train tracks and commence again as an accused person. And that is ultimately what the High Court has been compelled to do as a result of decisions like Istenek, which have forced it to consider these cases wrongly. The High Court has had to, well, let's just remind ourselves, Istenek regarded such people as convicted. It took the view that categorization was for the issuing state. It misread Caldarelli paragraph 24. The result of Istenek has been some fairly strong language from the High Court, treating people like the present appellant as convicted has been described as unfair, prejudicial, a matter of some concern, bizarre, absurd. And so since Istenek, the High Court has been scratching around for solutions to how to deliver justice in situations such as this. Some divisions of the High Court have simply followed the correct course, cases like Gomez, and treated people with retrials as accused as they should have done. Others have resorted to Article 8 as a kitchen sink in which justice might be found. That's Cousins. Others, Campbell, have employed abuse of process to bring proceedings to a halt, where somebody is in reality accused and would have been discharged had he gone down the right route of the act. But the court is precluded from sending him down the right route by the terms of the act.
Are you going to take us to the cases where it's been reclassified as an accused warrant?
We have does my lord mean...
I understood you to say a moment ago, I may have misheard you, that you're referring to Istenek, and you said that since then the High Court scratched around to find solutions. So one of the solutions was that some courts have reclassified the warrant as an accused warrant.
Oh, I understand. Those cases, my lord, for example, include Rahman, tab 53, volume 3, at paragraphs 32 to 37, where the court treated people with retrials still as accused people, as they always have been, and despite Istanek. Lewicki is another case, my lord. Paragraph 68 to 71.
Which is the reference to Lewicki?
Tab 62, volume 4.
Thank you.
Paragraph 68 to 71. Those are two illustrative cases in which the courts, despite Istanek taking a manifestly wrong turn, the courts have continued to apply Coppin, Foy, Bicar, Hewitson, and the like. For my lord's note, everything was fine until 2009. So what we have seen is the common law had been going on for 150 years. Caldarelli had determined that the law, the stream as we had been paddling for all of that time, was entirely consistent with the framework decision. Then came a case called Sonia at tab 36, where the court reasoned that because all trial in absence cases pass through section 20, and it's there that retrials accrue, and section 20 is applicable only to conviction cases, all must therefore be conviction cases. Wrong. Foy, Bicar, Hewitson say precisely the opposite. Retrial cases don't go anywhere near section 20.
Well, Foy, of course, was, as has been pointed out, a 1989 Act.
Yes.
So it cannot be cited as a contradiction of this line of authority.
Unless the scheme has radically changed, and Caldarelli told us that it hasn't.
You also concede that Section 20 is significantly different from Section 6.2 of the 1989
The
Act.
protections that are built into it are significantly strengthened, but I think I submitted that the scheme of Section 20 is precisely the same as the scheme of Section 6.2, and I don't understand the respondent to submit otherwise on this appeal. And we also know, of course, that even if, for the sake of argument, trial in absence cases were to enter Section 20 as conviction cases, it doesn't follow that they emerge as conviction cases Foy IB. Then Sonia seems to have been forgotten. The House of Lords in Gomes, paragraph 38, Lord Brown, with whom all Lords agreed, laying down general principles and guidance under Section 82, the Part 2 equivalent of Section 14, obiter but unambiguous. Their lordships had obviously given thought to the issue, and after that you have a series of cases in which the old position is maintained. MJ, tab 39, Rizika 40, Pizzo 41. Everybody is treated rightly as accused.
Gomez was concerned with Part 2, wasn't it?
Yes, it was, but Section 82
another
and Section 14
section,
are
the
identical.
same language, yeah. I think
It's
you
only then
say
that-
in your written submission, in your written case, that Gomez noted. I'm sorry, that's not right. That's wrong.
Gomez, obiter I accept, but manifestly supportive of the position I advance, as are cases like MJ at tab 39, Rizika at 40, Pizzo at 41. The wheels came off with Istanek in 2011, and it might be thought a matter of real irony that only months after the ECJ had held in IB that the common law had been travelling down the right river for 150 years, that the High Court should take the next available opportunity to divert sharply off course and into some backwater.
Which paragraph in Istanek
Istanek.
is the wheels coming off?
21 to 30, my lady. Entirely inconsistent with what had been said in Zeza about blindly following labels attached to EAWs. Entirely inconsistent with Lord Mant's paragraph 42 in Caldarelli. It's not about labels. It's about close examination of the applicable process. Entirely misunderstanding Caldarelli paragraph 24. And making again at paragraph 28 the Sonia mistake about how section 20 works. Everything that is said especially at 29 and 30 is consistent with an avalanche of cases that had gone before, not least of all Caldarelli, the House of Lords, under the 2003 Act. And that's where it all went wrong, and it's after that that the High Court has, to use my words, been scratching around to do justice, because they have been forced to treat people with retrials as people convicted. That's what Histonek requires them to do. So Campbell resorted to abuse of process as a way out. Campbell held that had Mr. Campbell been treated as an accused, as he should have been, he would have been discharged under section 14, and it was abusive to proceed otherwise. Cousins, tab 52, tried to do justice under what it called the kitchen sink of Article 8, but with reservations. Rahman simply ignored Istanek completely and followed Gomes instead, treated the person before it as an accused person. Paragraphs 32 to 37. Lewicki did the same at paragraphs 68 to 71. Rahman and Lewicki in our submission are entirely correct, as were all of those cases that preceded them. And in a case such as the appellant's, where there is an automatic right of retrial from the outset, the answer is clear and straightforward. They're accused, they always have been. Under the framework decision, they still are. And the stream of law should be restored to its proper course. But of course, this court will want to ensure that the restored stream is free from blockages going forward, and to deal with the situation of somebody who only accrues their right of retrial through Section 20. So they begin life as convicted, they emerge from Section 20 as accused. IB tells us they need to be retreated as accused. The obligation, Pepino paragraph 47 on this court, is to find a way to do so, which is why we have sought to address you on validity as a potential route and abuse, Zakrewski paragraph 13, as a potential route. But ultimately, there has to be found some route to retreat those people as accused with full access to all of those aspects of the Act that would have been applicable to them as an accused person, in accordance with the framework decision as authoritatively interpreted by the CJEU. Can I just, because I promised to do so, I think, my lady, Lady Black.
You have 4 minutes in which to do it.
Section 68A, subsection 2, might have been thought to be a route to do justice in Section 14 cases at least. Remember that Section 68A defines those who are unlawfully at large. Tab 70, my lord.
Thank you.
But there is a carve-out for sections 14 and 63. It might have been thought that that would enable the court, at least in Section 14 cases, to make up some other category of, or definition of unlawfully at large that did accommodate people who emerged as accused people, people with retrials. That's not how we read section 68A, subsection 2. As we understand that section, it's directed at a specific issue. It's concerned with that group of people who are convicted but not yet sentenced. And the purpose of that carve-out in 68A2 is to remove that group of people from the definition of unlawfully at large for those two specific provisions. Section 63 is concerned with people who've been repatriated to their own country to serve their sentence and then escaped from prison. By definition, that is only concerned with persons already sentenced. And removing the purpose of 68A2, as we understand it, is designed to prevent them arguing that they are somebody who's going to be resentenced, as can sometimes occur following repatriation. And the carve-out from section 14 is a parliamentary choice to treat those specific people as accused and entitled to consideration of a longer period. And in any event, even if the court were free to create some other definition of unlawfully at large that did justice to these retrial cases under 68A2, my Lord Lloyd-Jones in Wisniewski, paragraph 52, holds that on any view, unlawfully at large must mean liable to serve a sentence without further judicial order or process. There is, of course, such a process in prospect in a retrial case. So that, in 4 minutes, I hope explains why the courts haven't looked there for the solution. It doesn't give the required flexibility to do justice in these cases. The solution needs to be found elsewhere. My lords, my lady, unless I can assist further.
Thank you very much indeed. Mr. Seafood?
My lords, my lady, I have nothing further to add.
Thank you. Mr. Hardy?
May it please the Court, by way of preface, may we say that we agree with Mr. Summers' analysis of section 68A2. That was an amendment effected by the Police and Justice Act of 2006. And in the original Extradition Act 2003, as originally enacted, the unlawfully at large concept was incorporated in section 2. And it was removed and put out into section 68A for precisely the purpose that Mr. Summers identifies. We make the point, following up that particular matter, that of course Parliament declined to make any amendment to section 14 or section 11(1)(c), which is the originator, as your lordships and my lady know, of section 14. Section 14 simply provides a development and definition section, so to speak, an expansion section of section 11(1)(c), which section 11 identifying the various bars to extradition. That preface over and done with, may I seek to distribute a very short document to the court. Mr. Summers has had sight of it. Whilst refining my opening submissions yesterday, I wrote them down, and rather than invite your lordships to take a note, if your lordships think it appropriate to do so, of my opening submissions, they are there for you in writing.
Thank you very much. Excuse me.
And if I may, I'll just read them into the record. This case concerns the classification or categorization of the two classes.
Well, I don't think you need to read them all out. I mean, we're going to study them, Mr. Hardy. But if you'd like to emphasize any particular point, of course, you're free to do so.
Yes. My Lord, the points we emphasize are these. From the 1870 Act onwards, there have been two classes of people or persons liable to extradition proceedings. in shorthand, those accused and those convicted. Those two jurisdictional channels, if I can use that expression, under the various pieces of legislation have led to the difficulties which have been explored by Mr. Summers thus far in his submissions to you. We submit that there is an emerging thematic consensus in these authorities, and that thematic consensus for conviction cases defines a person convicted as somebody who is subject to a binding and enforceable consequential order. No matter that might be subject to some supervening process which annuls that order for the purposes of their definition as a person to be extradited, if a binding enforceable order is in place, they are, until that order is removed, often, as your lordships and my ladies see, in the authorities as a result of a procedure under the law of the requesting territory. Until that point is arrived at, they remain, for the purposes of the Extradition Act 2003, persons convicted. And they remain, if I may put it this way, within that jurisdictional channel. There is, as such, no crossover. And my lords, in that context, although it deals with the Extradition Act 1989, your lordships may find the analysis, I beg your pardon, not your lordships and my lady, may find the analysis of Lord Hope of Craighead, in particular in the case of Guisto at tab 29 of the volume, authorities volume, helpful, because he makes it quite clear you can only be one or the other. You cannot be both, and as we say in our written submissions, you cannot be both any more than you can be neither.
Well, you can't be both, obviously, but can you transform from one to the other is the real question, isn't it?
My lord, no, is the short answer to that. It is only as a result of some subsequent process in the requesting territory that you may be entitled to a retrial. The fact, and we accept, of course, as we must, that persons...
Sorry, that was a rather loose way of putting it. You may be recognised as one in the initial stages, but with the emergence of further information, can your status change because of the information that has been received? I mean, to bring it home to the realities of this case, the appellant was a convicted person in the technical sense, but given that he was entitled to a retrial, once that circumstance is acknowledged, could it not be recognised that his status needs to change?
We submit no. It's a matter of classification. There is no legislative room for moving between one channel and another. And
so once you enter the channel, even on incomplete information, your status is fixed for all time.
Whilst proceedings under the extant warrant continue, that is so, my lord. It may be the case that a requesting authority may say, well, actually, we shouldn't have convicted him, we should have accused him, we'll withdraw the conviction warrant and submit instead in its place an accusation warrant. But of course, that hasn't happened here, and with respect to my lord, it seems to us that this is a narrow question of definition, a narrow question of classification, and broader considerations will not help elucidate the answer to the question that's presently before the court.
In this particular case, there couldn't be a changed status at all, because if you look at the arrest warrant itself, it was clear on its face that there was an entitlement, if requested, to a new process.
Indeed so.
So there was no... He couldn't have gone in as a convicted person and come out.
Yes.
Well, your essential point is that the status is at the election of the requesting state. I mean, it decides how it's going to be described, and that's that.
It must be so, my lord, yes. May I, in that context, take your lordships very briefly to Article 8 of the Framework Decision at tab 69, and the memory stick page is, if you'll give me, memory stick page is at 1233. And Mr. Summers drew your lordships and my lady's attention to little letter F of sub-article 1, the penalty imposed if there is a final judgment. If one moves up to letter C, dealing with the
Sorry, which page are we on now?
I'm sorry?
Which page are we on?
1233, my lord.
1233, yes, thank you. Yes?
The contents must include evidence of an enforceable judgment, an arrest warrant, or any other enforceable judicial decision having the same effect. And there does appear to be a little interchangeability between the use of the term final and the use of enforceable. But equally, as my Lord Hodge observed in the course of my learned friend's submissions, at page 1242 in the template of the European arrest warrant, which is the annex to the framework decision. I pause to make this observation. The template appears not to be a mandatory document, it's suggestive, but if it's filled in, it will satisfy the requirements of the framework decision. 1242, your lordships and my lady, see box B, decision on which the warrant is based, either an arrest warrant or an enforceable judgment. And on any evidential analysis in this case, that is what this European arrest warrant contains, an enforceable judgment. The mere fact that it can, at the person's election, be set aside on his return doesn't in any way alter its character or its status, nor his classification or categorization. And that is, if you like, the essence of our case. May I, before I continue with my submissions directly on the point, just deal with two matters raised by my Lord Kitchen and my Lady Black concerning the interrelationship of the framework decision and part 1 of the 2003 Act and the question of transposition. My Lords, the Extradition Act 2003, contrary to the predictions of the government that enacted it, has in fact spawned an enormous amount of litigation, as this court knows all too well.
That's not an unusual phenomenon.
No. My Lord, can I take your Lordship to the first two cases which went to their Lordship's house, and in particular to the analyses of Lords Bingham and Hope, so far as this enactment is concerned. The first such case is at tab 32, the first case to go as far as the House of Lords, the Office of the King's Prosecutor, Brussels, against Kando Armas. That commences at page 542 on the memory stick, my Lord. And the speech of Lord Bingham commences at page 548, and at paragraph 7 on page 551, Lord Bingham points to Article 34 of the framework decision, which requires compliance and requires member states to transmit to the Council and the Commission the text of provisions transposing into their national law the obligations imposed on them under the decision. In fact, as will appear apparent, the United Kingdom did not directly transpose those provisions, unlike, for example, Belgium in the IB case that the court has been taken to. Lord Hope, at page 558, at paragraph 26, says this: one might have expected the draftsman, when he was prescribing Part 1's contents, simply to have followed what the framework decision says about this. And then he goes on, and I don't need to read any further, my lords, but the point is made, there is not in fact a direct transposition. And if I may illustrate that by, I hope, an obvious point, section 11.1c, the passage of time bar, as expanded in terms of definition in section 14, appears nowhere in the framework decision at all. The only Article 4 of the framework decision, optional ground for non-surrender, relates to limitation periods, which of course are common in civil code jurisdictions amongst member states, but less so under common law jurisdictions. But there is no direct relationship at all between our passage of time protection and the framework decision itself. Turning on, if I may, into Dabus, the second case at tab 33, beginning at page 569, can I take the court to paragraphs 23 to 25 of Lord Hope's speech, beginning at page 582, and may I just invite the court to read that, or the members of the court to read that to themselves.
Yes.
Which paragraphs were they?
23, my lady, to 25, pages 582 to 583.
Yes.
So in short, there was no transposition as such of the framework decision, as is the position with such instruments. Implementation is left to member states to deal with as they wish in terms of their national legislation.
But insofar as there's European law jurisprudence on the question, we must follow it.
Indeed so, yes. And with that, may I turn to the case of IB? At first volume of authorities, my lord, tab 2, page 38. And I hope I can complete my analysis of this authority before the short adjournment.
Good.
Did you say tab 38? No.
The one,
Page 38. Page 38.
38.
Tab 2.
Thank you very much.
Yes.
And we make 4 points about this authority. First, as has been noted by my Lady Black, and by my Lords Lord Lloyd-Jones and Lord Hodge, this deals with a sentence which was not enforceable under the law of the member state in question. And we find that, first of all, in the head note, in the holding, in the penultimate line on page 38, We find it also in the judgment of the court on page 61, as has already been noted by members of this court, at paragraph 56. That's letter H on page 61. And insofar as it's relevant to the consideration of this court, we also find reference to it in the opinion of the Advocate General. And can I take the court first to paragraph 21 on page 44, memory stick reference, where the Advocate General sets out the issue over characterisation of the warrant. And then invite the court to continue to page 48 at paragraph 36. At paragraph 36, which, if I may, I shall read. Although the two questions, that is to say the two questions referred, and ultimately the court only found it necessary to dispose of the first question, which Mr. Summers has already drawn this court's attention to, so I won't repeat it. Although the two questions appear to address different issues, I think that they can be answered together. As I shall explain, the crux of this case is the interpretation of Articles 4, 6 and 5.3 of the Framework Decision when an arrest warrant is issued to return a person to the issuing member state and he or she is retried there. How the warrant is actually characterised is a matter of secondary importance. And we submit that there is force in that because, as has been observed by some members of the court to Mr. Summers during the course of his submissions, the reality of this case concerns the interpretation of Article 5, Sub-Article 3, and whether that article and that article alone can be applied in a conviction in absence case. And the view of the court and the opinion of the Advocate General chime together in the sense that both say this article can be expansively interpreted and applied in a situation which, as my Lord Jones noted, is comparable to that of a person facing an accusation warrant. Comparable, but by no means identical. And so we submit, I'm not sure whether I heard Mr. Summers correctly. No doubt he'll put me right in his reply if he needs to do so. Where Mr. Summers said all the accusation protections under the Framework Decision also have to apply to a person whose return is sought as a person convicted in absence but entitled to a retrial, the reality is that the only protections are to be found in Articles 3 and 4. Those are the mandatory and optional grounds for non-return, non-execution of the warrant, and Article 5, which enables the executing judicial authority to seek a guarantee from the issuing judicial authority, as the court has seen. So, on that basis, we say it's a narrow decision. It concerns the interpretation and extent of Article 5.3. It doesn't purport at all to reclassify a person convicted in absence as a person accused, nor does it purport to treat that person as such. He or she is still returned on the conviction warrant. The second point to make on this particular authority is that it's permissive. It is not definitive, still less is it mandatory. It permits the extension of Article 5.3 in these limited circumstances. It does not redefine the person as a person accused, nor does it make it mandatory for the executing judicial authority to treat him or her as such. And may I return in the authority to the Advocate General's opinion and invite the court to consider paragraphs 47 through to 53, beginning at the bottom of memory stick page 50.
47 to 53.
47 to 53, and again, can I invite the court to go without my reading it aloud?
Thank you. Yes.
My Lord, I've effectively amalgamated two of my 3 points, namely the permissive point and the limitation to Article 5.3 point. And we make make what is now a third point. Given that the authority is not primarily, or we say in reality at all, concerned with classification, it can therefore have no assistance to this court in construing a domestic piece of legislation not reflecting the framework decision, but having considerable legislative history of its own, which I shall come to after the short adjournment. And if I may say so in conclusion on this issue, that if, and I understand it to be the case that Mr. Summers says this case is effectively his high water mark, I'm afraid it's come in at rather low tide.
Right.
And with that observation, although we're slightly early, may I invite your lordship to...
We'll take advantage of the tide and sit again at 2 o'clock.